And thank you for being here. In addition to what Kenneth mentioned, I'm also a trustee here, so behavior center. I selected that picture to introduce it because I know you've been here all winter, and I wanted to remind you that someplace in the world there is warm sun and a beautiful beach and warm water, and pretty soon, just hang in there for a little while longer. Just wanted to let you know that. What I wanted to do, my colleagues here focused on the legal side for the most part of the licensing process. I wanted to just begin by painting a slightly different picture that I hope you can keep in mind as we proceed, and that is looking at the licensing process from a business standpoint. And we heard a little bit this morning about how that enters into the practice. No question about it, intangible assets and intellectual property are the fastest growing and the biggest value in businesses worldwide. Nobody really disputes that. But I would suggest to you that an important thing to keep in mind is the fact that intellectual property is different from any other business asset. And it's different because its ownership rights are transferable, and those rights can be exploited simultaneously by different parties. A little different than a factory or a building or a piece of land. And those characteristics mean, because it can be simultaneously exploited, that results in the fact that then licensing, that is the distribution of those rights, becomes a very, very big factor in the exploitation of intellectual property. Now, I use that word exploitation, and some feel it has a negative connotation, but all I'm referring to is the employment of intellectual property for an economic benefit. If we look at a license in its simplest form, it's an exchange of rights for cash. I prefer the lower definition that it is a division of the future economic benefits of ownership between two parties, between the licensor and licensee. And I prefer that definition because, first of all, economic benefits can take many forms, and we need to recognize that. And second of all, it tells us that what's really happening here is the total bundle of rights are being divided between licensor and licensee. I liken it, I think this is an artist's reproduction of the Three Gorges Dam. I liken it to a dam, however. If you can picture that the impoundment of water behind the dam represents all of the future economic benefits that can be obtained from ownership of some form of intellectual property. That's the totality of it. What the dam does is redistribute that impoundment for various uses. Some of it goes to generate electricity, some of it goes downstream for recreational purposes, some irrigates fields, some's drinking water. You can think of all different kinds of things. And to me, that's what a license does. It takes that total impoundment, the total future economic benefits of exploiting some form of intellectual property, and distributes it among different people. Now, it can be all retained by the owner, and there can be no distribution, no licensing, or it can be extensively licensed. Obviously, the assignment is the total license of all the bundle of rights associated with it. But to me, this illustrates what we're trying to do in a license, this allocation between licensor and licensee. I would also suggest to you that there's two main categories of licensing. There's internal licenses, that is, licenses between parties of a controlled business. And there's also external licenses where license is given to someone external to the owner, external to the owner's business. Why do we have internal licenses? Well, in some cases when businesses want to concentrate the ownership of their certain kinds of intellectual property, it's proper for them to have a license between their parties. So there's internal and external. Visualize two ends of this slide are two different parties within a license, and this is the typical description I just gave you. You know, an exchange of IP rights for cash. However, if we look at both sides of that cash transaction, the party on the left is incurring an expense in the payment of that cash. The party on the right has some revenues as a result of receiving that payment. We don't have time to talk about tax issues today, but I would suggest to you, and I think that my colleagues will agree, that the tax issues connected with the flow of money in terms of, because of licensing across national borders, is a huge, huge issue, and an extremely complex issue as well. But it's something, while we're not going to try to address that sort of thing, it's something that you have to be aware of in that process, that there are significant tax and financial reporting implications of a license. And what happens is, this is an expense over here on the left, it's also potentially a tax deduction. On the right, it's taxable income, perhaps. And if we name those two territories, one being big tax land, and the other side, that entity's in low taxia, you see what the problem is. And you can see right away that the tax collectors on both sides of that transaction get very, very interested in it. And there's a tremendous amount of money flowing across national borders today, and there's going to be even more tomorrow. So I would say that all of these transfers, of which the licensing is one, are a very, very big target. There's not an entity, national, state, provincial, municipal, any kind of a governmental taxing body that you can name anywhere in the world that isn't short of money right now. So that makes this issue very much more important. So it's IP rights and the money transfers connected with IP rights are a big target, and they're getting much bigger. So with that, I'd like to pose a question, and I'm going to ask Larry Grace to address this for us a little bit. This is about domestic and international licensing, and to try to maybe paint a little bit of a picture for us about some of the characteristics of international licensing that are the same or different than we would address in a domestic situation.
Okay, well, to start off with, in the legal sense, a license is basically a promise that the rights owner is not going to sue the licensee. At its heart, that's what it is. The licensee's activities would be infringing on the licensor's rights, but for this agreement. Inside the US, that's a very neat and clean relationship. In a number of countries, it isn't. And so whereas in the US, you can turn off the switch really neatly and cleanly, either on the termination of a license by its term, or if there's a breach. In a number of countries, and strangely most of those countries are what I would call IP recipient countries rather than IP inventor countries, you get sticky rights. You license a trademark and you say you can use this trademark to distribute products, and it comes to the end of the license term, you may not be able to just turn off that stream. In a number of countries, you would have to pay compensation to the licensee if the licensee has made substantial investments in it. So that's one layer of complication. The second is, again, within a single national boundary like the US, you have rights that apply throughout the territory. Copyright, federal, great, all is fine. And international, because of the Berne Convention, as most of you should know, functionally it's a universal right. As soon as you get into other trademark or patents, it becomes highly territorial. And in the patent world, you either have a registered patent or you don't. That's really simple. In the trademark world, well, now we have to talk a little bit of comparative law. The world is divided between civil law countries and common law countries. One of the interesting vignettes about the common law is that it is always spread by the sword. No country has ever voluntarily adopted the common law. It's always a matter of armed conquest. So all of the former British Commonwealth countries, they got it that way. But once it's there, it never goes away. Why? Well, a cynic would say because when the lawyers and judges have that much power, they're not going to give it up. In the civil law world, there's a minor subdivision between those that follow the German civil code and the French civil code. But what you get with all of those countries in the trademark world is if you don't register, you have nothing. In the common law world, you have common law trademark rights. Okay, that's all nice and warm and fuzzy and buys you exactly nothing in the civil law world. So you, in the trademark world, when you're going to launch a brand or expand or something, figure out where you're going, get all those registrations under your belt, because if you don't, somebody else will. And in a common law jurisdiction, you knock on the door and say, excuse me, you know, I'm really the rightful owner here, and this guy's a pirate and he's a pretender, and the common law judge will say, oh, be gone, pirate. In the civil law world, oh no. First to register is first in right. They don't care why somebody registered those rights in Bolivia. People make a really good living in a lot of Latin American countries reading the financial pages, figuring out what countries are going to start using a mark there. And by the time the ill-advised US company gets there, he finds that his mark belongs to somebody else. Got to ransom it. So that much for the comparative law introduction, and also the principle of territoriality that applies. You also do have to be careful of rights that exist in some places and not others. Things like the schematics for an industrial plant design, which are protectable under the EU law. And in the US, if it's not a trade secret, and guess what, if you've registered in Europe, it's not a trade secret anymore, you can't protect it. So there are places where territoriality means a binary, there is or is not the existence of it.
So in a sense, what you're saying is that that affects your ability to license into that territory.
Exactly. That's how much water's behind the dam.
Yeah.
And in some territories, there's a big old wastegate that says, can't exploit it here.
Good point. To me, software is licensing in the software area, while it's, a great deal of it is being done, is maybe one of the murkiest areas that there is. Can you enlighten us on that a little bit and spell the murk, perhaps?
I can.
Oh, okay.
That's two
okay.
questions.
We'll just go
Yes
right
and
on
no.
to the next.
Well, it's an interesting area of the law because, excuse me, much of the negotiation involving software, well, first of all, let me just tell you where I'm coming from. Software, when it comes to licensing, is usually very large-scale software systems. We're talking about systems that have been developed over the course of decades, usually. And you have this pre-existing package, which is worth hundreds of millions of dollars based on the research and development that have gone into it. The licenses, the contracts that we enter into, are worth millions of dollars over some period of time. That software, it exists at the moment that the salesperson sits down with the potential licensee. But it has to be changed in almost all cases so that it fits the business needs of the licensee, and so that it also fits the back-end operating system of the computers that already exist at the licensee. So the strange thing about software is, if you are the licensee, the customer, you really don't know what you're getting. You know what this package looks like in the pre-tailored or pre-customization stage, but it could actually look fairly different by the time it's implemented on your system. So it's almost like a construction project. You have something in the way of specifications, but it's going to change over time. So you don't know what the end result's going to look like. And you as the licensee, during this whole change process, this customization and tailoring process, you're paying money. So that's what makes it kind of murky, because from the outset, when they start calling the lawyers in, after the business people have kind of decided on what the dollar amounts are going to be, we don't know what this product is going to look like, and so therefore we have to build in various mechanisms within the contract that account for various contingencies, so that if it doesn't look like what the licensee expected, or it doesn't operate the way it was intended, then there are escape valves or penalties or things like that. So in that sense, software contracts are very murky because we don't know what the product looks like. They're also murky in the sense that these contracts are highly negotiable. As Gordon's going to talk about, much of these software deals involve really just business terms. I mean, there is some protective aspects of each contract. For example, in every contract that you represent the developer on, that is the copyright owner or the licensor, you're going to make sure that you own it. You're not giving up ownership rights. You're giving out a license, a little piece. But because it's ultimately a business deal, so many of these terms are negotiable. And yes, there are certain risks involved in giving up rights, let's say on indemnification, giving up rights on, let's say, well, let me just pull a couple up. Number of years, things like that. It ultimately boils down to a business decision that you, as a lawyer, you can't make that decision. It's ultimately up to a business person. You'll work in conjunction with the business person so that you advise them what the legal risks are, but you don't want to be a deal killer, which a lot of lawyers feel that they are. A lot of lawyers feel that they have to make sure that every single term within the contract is to their liking. It's just not that way in software contracts. What you do then is you pick out those terms that are really important to you. You don't let the other side know this. You pick out the ones that are important to you, you pick out ones that aren't important to you, and then you play this sort of chess game, this negotiation process, where you get the things you want, and you give up with a little bit of fight the things you don't want, but you trade them for the things you do want. So, yes, it's murky. Is it the same for every deal? No, it depends on every single deal has a different situation. Even if you're dealing with the same licensor and the same software package, you're always dealing with a different licensee, and each contract can look very different. So from a very high level, 30,000 foot point of view, that's the murkiness involved in software.
Typically, what does one of those licenses look like in terms of what's included, I mean, in a general sense?
Ownership, we always specify, if I'm representing the developer, and I will represent the licensee in a lot of cases, ownership is a must. Software developer must own it. There is something called the license grant, which is covered in your copyright licensing class that Mary Wong teaches. That is, what is it exactly that we're giving to you? What are you allowed to do with the software? Are you allowed to make copies? Which actually is sort of an old concept of copies, because it suggests that the software is residing on the licensee's computer. That's less and less the case these days. More software is residing on the developer's computer, being hosted by the developer, which is called an ASP, or Application Service Provider Agreement. You have a term for years. Usually these deals are something in the range of 7 years, because these are very large software projects. If a company is going to invest, let's say $20 million, which is not unusual, they want to make sure they have the right to use it for 7 years. There are customization and tailoring terms. Exactly how are we, the developer, going to change this thing so that it fits your system and your business needs? Fees. We have to determine in advance what those fees are going to be. They might change a little bit depending on whether the specifications change over time, but you want to know with 99% certainty what those will be. Milestones. When will the software be delivered? Will it be delivered in stages? Does the developer get paid in stages? There's something called acceptance testing. The customer, the licensee, has to test everything, try to basically make it blow up. And they test it until it works to their satisfaction. There are things called service level agreements. Will the software operate as it's warranted? If I'm hosting it, for example, I'm the developer, do I promise that my server will be up 99% of the time? Do I also promise that when you press a button, will the system response time be 2 seconds or less? There's all sorts of different warranties and what we call SLA, service level agreements, that come into play. You can also, we always, in software agreements, limit the warranties. We limit damages. We often provide indemnifications. That is, if a third party sues us, one will protect the other. We also have things like confidentiality provisions. The strange thing about software is it's really never published in the copyright sense in these large deals. It's not stuff you buy off the shelf, which is in a sense published, or that you download by FTP. These large-scale systems are basically delivered privately, and so therefore you have confidentiality terms. So much of the software is actually protected by contract and is therefore a trade secret. We have termination rights, we have arbitration, we have bankruptcy, we have something called source code escrow, which is where the software is held by a third party in case the developer goes bankrupt. You, the licensee, want to have access to the code just in case you need to fix it. And then there are other standard boilerplate terms that you'll find in pretty much any contract.
One of the things, those of you who may have sat in a class of mine have heard me say this. One of my beliefs is that every license clause has some economic weight. That is, whatever those clauses are, shift that division between licensor and licensee, and as soon as you shift that division a little bit, you're going to shift the division of future economic benefit, and you're probably going to shift the amount the licensee is going to pay or the licensor is willing to accept. Do you find that, I mean, when you gave us a list of clauses and considerations, do all those things go together to move that compensation number?
Sometimes. If I represent the developer and the licensee wants some particularly onerous term, and that could be one of 100 different things, in some very rare cases, the developer will come back and say, we hadn't really accounted for that risk because there's a substantial risk of substantial cost or damages, we'll need to increase the price on you. In most cases, however, the risks of something going wrong with a tried and true system are pretty low. And what we'll do sometimes is not necessarily raise the price, but we'll use it as a bargaining chip to get some term that we really don't want. So let's say we want all matters to be litigated in a New Hampshire court. We'll trade that for whatever term it is that you want. So yeah, it definitely tips the economic scale, but you have to look at it in purely business terms. First of all, what does the lawyer say could possibly happen? But then, what is the risk of that actually happening? If it's only 1% risk of $10 million in damage, then the 1% times 10 million is really only $100,000 potential risk. Is that something we can live with? Sure, we can. Will we do that multiple times in a contract? No, we'll do it a few times, but if the customer insists on many terms in their favor, then the price does go up. So it's this bargaining process. It's a little bit of a chess game. You always negotiate high. You always start with terms that you want at a very high level, but you know they're going to get compromised down. And similarly, the licensee does the same thing. They'll start low, you start high, you meet somewhere in between. Now, it sounds like it's a very antagonistic process. It usually is not. You get along pretty well. The most antagonistic that you will get in this entire partnership is when the lawyers negotiate these terms. But it's usually pretty civil. But one thing we have to keep in mind is when it comes to these software deals, it's not like selling a widget. We're in partnership for at least those 7 years that we talked about. We need to be able to work together, and we have to, from the very outset, make sure that both parties are at least satisfied with the deal. Nobody's ecstatic, but they're satisfied, so that there's no hard feelings from the outset. So therefore, we can work as partners down the road. So that is one factor that comes into play when you're making these sort of business decisions, especially about the contract as a whole, is to keep in mind that we're going to be working together.
Any thoughts about clauses in economic weight?
Well, a couple. The software licensing representation that I do isn't nearly as large scale as that. So in the context of a small scale party, most of the time, if you're trying to sell a system to a big customer, you get their form of procurement software license, and they won't negotiate based on your form. If you want to sell to General Motors, you get something that they got back when they bought EDS, and that's the form you get. And so, you know, you can try to negotiate a bit around the edges, but you're not going to get your form in. And most of the time, they're going to drive a very hard deal. So I have to tell my client, look, we don't have a lot of maneuvering room here. You either say this customer is worth it or it isn't. You do get to set your price. And if they're asking for a whole bunch of stuff that you know is going to cost you money, if they're demanding 24-hour customer support on a telephone, that's different than 16 hours. And it's different than we'll get back to you within 1 business day on email support, and so on. So if this has a price impact, price it into the deal. And if they say yes, well, okay, then we all know what we're playing with. But I have one client where just to do Fortune 500 companies, we set up a disposable licensing vehicle. And it's because the indemnity clauses that all these companies insist on, which is full-blown, third-party, any-and-all claim, even patents you don't know about and couldn't know about at the time you did the license. You've done nothing wrong. You've taken nobody's copyright. You've used 100% of your own source code, but somebody comes in with a patent from out of the blue. Okay. So we got to defend this. Not a problem. We have a disposable licensing company. And that company does all its licensing, and if someday one of these patent trolls or other characters shows up and knocks on the door, and your customer says, oh, well, guess what? You have to defend us now against this patent litigation suit, and you know the down payment's $500,000, and just start writing checks from there. And we say, sorry, disposable company, bye. So sometimes there's that dynamic involved when you're representing or dealing with one of the smaller licensing companies.
That can present a problem, sorry to interrupt.
Yeah, go ahead.
Big companies often have horror stories when it comes to licensed products, and because of that, they learn these lessons. So the next client that they deal with, or the next developer that they deal with, is going to be met with resistance on terms like indemnification, things like that. They're going to insist upon it. And that's okay. I mean, when you talk about a company that really is looking long-term and we're dealing with very large dollar amounts, they'll usually agree to something like indemnification. That's pretty much becoming standard these days. Is there risk involved? Sure. But are you really betting the company on it? No, not really.
Ron, if I'm the licensee of a kind of a software package that you described, and I'm a multinational company, and my overseas divisions, subsidiaries, whatever, are using that software, does that present issues, either here or in their home country?
In terms of the IP?
Yeah. Are there any pitfalls in that?
Usually it's not a problem. The only time that there's an issue that might arise is if the software is being so highly customized that we may run into some sort of copyright issue overseas, and in which case we want to make sure that the overseas office as well as the U.S. office doesn't get any sort of ownership right to the software. So what we do is we build into the contract all sorts of language that hopefully covers all these different countries dealing with like moral rights and droit moral, I don't know if I pronounced that properly, things like that. We build that in so that just in the off chance that somebody can make an argument that because they suggested a new little tweak on the old system or a new piece of functionality that they own it, we put that into the contract. It hasn't been tested yet in any of my contracts, but hopefully that covers it. There are some huge issues, though, when you're dealing with overseas entities, where you're dealing with, and this is not IP, but you're dealing with personal information. A lot of other countries have very, very strict controls over personal information or sensitive information. And the problem there is what happens if it's breached, a hacker gets hold of this stuff. There you have indemnification that comes into play. There is more risk involved there, but it can be hopefully minimized with technology. So when it comes to hosting, if the developer is doing the hosting, let's keep it here in the United States. That avoids some other countries' personal information issues. But if there is that breach, sometimes that could bankrupt the company, only in personal information. When it comes to corporate information, though, laws aren't quite as strict. So IP, we're as careful as we can be because it's a little risk, but not a huge one. When it comes to personal information, it is a big risk, and we can try to manage that with technology.
Yes?
When you're licensing software and the licensee is looking to mass marketing at some point, like sub-licensing, I don't know, with click wrap or browse wrap or something like that, what are special considerations for the licensor in making that initial contract? They're going to be licensees going to be turning it around maybe to consumers. Yes.
Okay, so really you're getting into a distribution contract kind of area. Pretty much. Very frequently found in the international context that the party that's perfectly capable of exploiting the water behind the dam in the U.S. doesn't have the sales infrastructure to sell in Mercosur or something like that. So fine, you say, you're going to be our master distributor, and you're going to sell very happily in Brazil, Argentina, Uruguay, fine. Knock yourselves out. Yeah, lots of issues. One of them is in many of those recipient countries I was talking about, you have to register an IP license. There are tax consequences if you don't. There sometimes can be forfeiture of certain intellectual property rights in some countries, so you got to watch that one. You get sticky rights problems. That distributor then under, and by the way, in the last month I've been on the opposite side of this issue, so it's kind of fun. On one of them, we've got a brand company that gave my client distribution rights in a whole group of territories. And knowing about this problem, they provide for arbitration in a strangely chosen jurisdiction in the US. And so technically, at the end of the term, there is no compensation owed, and the whole contract is governed by the US law of the state of X. And they issued a termination notice, and I tell my client, well, not quite so fast. They may think they can turn off the switch, but in reality, as to the protection of distributors in all of these different countries, it's the mandatory law of those countries that applies. And so if the distributor in the local country commences a judicial action in that country, the court is very unlikely to say, oh, it's our obligation under the Panama Convention to disregard this lawsuit and refer it off to arbitration, when they know that their mandatory law is not going to be applied. And so, yeah, no, it's not nice and clear cut. You may not be able to turn off the switch. The flip side is I was advising a different client who was going to engage a distributor in Brazil, and they got this nice contract drafted by a Brazilian lawyer who also happens to be a principal in the distributor company. And so I said, no, client, I'm going to get an opinion from my friend, the Brazilian lawyer, because I think I know the answer to this, but I want to be sure. And sure enough, yes, Brazil's one of those sticky countries, and even at the end, you're going to owe compensation. So it may say it's a 2-year contract, but it really isn't. Okay, so that's at issue. Sure.
I didn't mean to interrupt you. I'm just trying to ask a continuing question. If that is the case, at what point do you, in the negotiations, do you think it's proper to involve a local counsel?
If the dollars are significant, it's always worth
What I'm asking is at what point, in terms of at what point in time, is it wiser to, let's say that you are starting to negotiate, is your first step, let me go talk to somebody there, get all the landmine signs go up, or should I wait until the general agreement is reached and then go and have it?
No, I don't like to wait to the end. The reason is, if I'm pretty sure there is a deal to be made, I'm going to give my form to my local guy there and say, you know, tell me if I get everything I want in this form, what the result is going to be under the local law if somebody commences an action there, even though we've got an arbitration provision that says we're really going to do this in LCIA in London. And so I involve them early because I want to know in the course of negotiating the contract what I'm really negotiating.
However, when you say that you're sending your form, in order to send your form, there are certain things that you need to know about what is doable and what is not, even before you're getting to that level.
Well, by the time you've been doing it a while, you do, but even if you don't, even if you would just say, look, this is the form that we use in the US, and I want to use it in this transaction, can you tell me, Brazilian lawyer, how would this be enforced in the context of a Brazilian licensee? Can I actually terminate it? Do I owe compensation on the termination? Do I have to register the rights? Are there tax angles? Am I going to be subject to local taxation or withholding or something in Brazil? Tell me all of the stuff that I may not know that is going to apply to this transaction.
Before you start to negotiate, basically.
That's
then
what,
negotiate after.
if I'm pretty sure that there's a deal. I mean, obviously, I'm not going to go flushing money if my sales guy says, oh, I've got an inquiry from Singapore. No. If the principals have exchanged the notion and there's what I think is a willing licensee and a willing licensor, I'll involve local counsel early.
But you don't draft the contract from the ground up. You already have a standard form. So that's what you're sending. And yeah, you do get the local lawyer in Singapore involved right away, because there could be something that's unique to Singapore law that you just don't know about. And that could raise the price, or could increase the risk. So you're not developing these contracts section by section by section. One party is saying, here's the contract, let's start working from this. And the way it works usually is you exchange it by email. If I'm working with a developer, we'll have standard contracts. We send it to the other side in Word so that it is editable. They edit it with track changes mode turns on, and you do this back and forth, and it goes on usually for months, sometimes as much as a year. And at the very end, there will be 4 issues or 5 issues or something that's a very low number. That's when everybody gets on the telephone and you start trading horses. You say, all right, I'll give you this term if you give me that term. So up to that point, everything is done electronically. Usually it takes 1 or 2 phone calls to finally resolve the thing. But you're starting with a contract. You don't build it from the ground up.
Hi, a question about your perspective regarding whether you're going to go to court or you're going to go to arbitration. And I'm not sure what country you're in, but I'm just curious as to the country you're in where you said the jurisdiction, if you took it to the court, they're likely to say, yes, we'll take it, as opposed to going with a party agreement that had an arbitration clause that said we're going to arbitration. Was it in a country that was part of the New York Convention?
Let me explain. First, in the context of international agreements, generally, you're going to want arbitration rather than litigation. Particularly in the context of a license, you're going to want arbitration someplace other than the licensee's jurisdiction. However, having done that, okay, that doesn't necessarily mean that a local court, notwithstanding the fact that the contract has an arbitration provision, will abide by the obligations of the applicable New York or Panama Convention and decline to assert jurisdiction and refer it off to arbitration. And there was actually a rather interesting, you'll have to pardon the momentary digression. What was this jurisdiction? U.S. court just did this, and it was actually, I want to say, Southern District of Florida. It was a Jones Act seaman case, and the employment contract of the employee provided for arbitration somewhere else, and the U.S. court said, wait a minute, if we go off and let you arbitrate this in Panama, well, the Jones Act isn't going to be applied. We know it's going to apply. This contract says no Jones Act. This guy isn't going to get his Jones Act remedies. Well, it's the same kind of a thing. The court in the local jurisdiction is going to say, hey, wait a minute. You're trying to take the distributor, who's a Brazilian company, and you're going to deprive him of his rights that he's got as a Brazilian company by having him arbitrate in the state of Missouri under Missouri law. We're not going to let you do that, you big, nasty, mean, rotten Yankee imperialist. No, okay? We're going to apply our law in our court, and you don't like it? Yeah, go ahead. Interesting result, by the way. This can result in a standoff. Okay, you've licensed your rights, and so you've now got an exclusive licensee in Brazil. The Brazilian court says you can't turn off that license. So you can't now license it to somebody else, because that licensee is going to sue your successor licensee. Really, really a problem. Now it's blocked. And this can happen with distribution of products. It can happen with license of the rights themselves. Pharmaceuticals, you had an interesting, we're supposed to talk about pharmaceuticals, so I'll drop a footnote on those. In patent licensing of pharmaceuticals, a number of the recipient countries have compulsory use provisions in their law. So they'll say, fine, you can register your patent here, but if you don't use it, yeah, we're only signed on to the Schumpeter School of Economics so far. We are going to insist that if you aren't going to make use of it, somebody else is, and we will do a compulsory license to somebody else in our territory. So, yes, check for pharmaceuticals.
Okay, thanks. Your comment, Larry, about the disposable companies raises a question in my mind. In acquisitions and mergers, where both parties are licensors and licensees, not necessarily of one another, but of other people, what are some of the pitfalls? You know, any horror stories of where those become an issue in trying to consummate a merger or acquisition?
Well, a lot of the time, the due diligence in M&A will surface problems that managerial staff at the mid-level have swept under the rugs. Frequently, they will involve things like privacy rights, things, and there have been a couple of fairly well-publicized cases where, in the context of an M&A transaction, it surfaces that, ooh, gee, we haven't been complying with the European Directive on personal property, personal privacy rights. Well, in some of those jurisdictions, you've got a compulsory disclosure. And so, and what gets really ugly is when the due diligence is done post-acquisition. That was the worst one that I saw. It was like 2 months afterwards. Then people start digging. They find the scope of the problem. They gaily report off. And of course, they know that they've got an indemnity right against the seller. And the seller doesn't control the process and has basically turned the keys over to the vault to the buyer. So you do have to be really careful. And in the context of indemnity obligations, you don't want to inadvertently consolidate subsidiaries of your acquired company without really carefully evaluating why they exist as separate compartments.
Any thoughts about that?
Mergers and acquisitions being possibly nixed by some bad contract terms?
Yeah, or maybe post-acquisition discoveries of existing license.
A lot of licenses say no assignment. And I think that doesn't make sense like in the widget world, but it actually could make sense in the software world, because if I'm representing the licensee and the developer wants to merge or be acquired by a larger company or even a smaller company, I want to make sure that my software is going to be maintained, especially if you, the developer, are hosting it for me. I want to make sure that this $20 million investment is going to be fruitful for at least those 7 years. I'm actually looking for more than 7 years, but that's all I could get my boss's boss's boss to agree to was 7 years. Well, I want something long term. What I'll do is I will write into the contract, no assignment, period. Sometimes those things are ignored. Often the way it works is the company that's going to be acquired will send a letter to the other party saying, we are being acquired by so-and-so, please sign on the dotted line at the bottom. The other company signs the dotted line, sends that essentially modification or amendment to the agreement back. Might not be the right person within the company who does it. Do they have the authority to do that? I don't know, it might be the techie who signed it. But nonetheless, that is the way sometimes it's gotten around. But there are some, when it comes to banks, they're particularly careful because they're subject to very strict US laws, rules, and regulations that require them to know who all their third-party subcontractors are. And what they will do is insist that they have the right to approve your potential acquiring party in advance, and also the right to nix the deal. Well, not nix the deal, but terminate the contract. If that's like one of your major contracts, and the acquiring party is paying you $100 million based on that particular contract, uh-oh, that's a problem.
Yeah.
Suddenly the price goes down where the deal doesn't go through. So in the software world, usually assignments are not allowed. We will build in things like to a substantially larger company, provided that they explicitly agree to adopt the terms of this agreement, they abide by it, so on and so forth. One thing we will build in there usually, however, is something that says, however, the acquired party may not be acquired by a competitor of the licensee or the licensor, whoever's on the other side of the deal. So yeah, it can be a really sticky situation, and if you don't do it consistently among all contracts, then you could have a problem when the companies get acquired.
Thanks. Yes, Tom?
And something that's bugged me for a long time, you got a license and the license is breached. You see the contract and you assume it can be a patent license, it can be a trademark license, it can be a copyright license. At what point can you say, I would breach a contract, you're an infringer, if you breach the contract?
That's one of those things that should be a really simple and clear answer.
That's what I thought.
And unfortunately, having litigated a couple of those cases, the jurisprudence on it is, well, judges always, it's a common law thing. They like to be able to pull something out when they want to tip the scales. And so you seldom will see a nice, simple, didactic statement, principle of law by the appellate court that says, yes, it's really easy. If you breach the contract, you are now an infringer. It's a facts and circumstances determination, It is unfortunately not as clean as you'd like it to be. But that threat always exists. And so if you are if you're either party, you have to be aware that you may be facing the full panoply of remedies of an infringement, particularly if it's willful. You're a trademark licensee, and you say, to hell with you, I'm not going to pay any more royalties, but I'm going to continue to use the mark and continue to put it on products. A situation like that, yeah, you can expect treble damages and attorney's fees and and have fun fighting your way out from gross revenues to gross profits. You're on the wrong side of the curve, and the court's going to throw the book at you.
Well, I'm glad to hear you say that, because I thought I was missing the answer.
Maybe before we finish, I just wanted to pose one other question. In your licensing experience, Larry, I'll go for you first. What kind of skills besides your legal skills and training would be useful in that?
Okay. As soon as you're talking about international, it's really good to know about what happens when things go wrong. So you want to know the international dispute resolution dance. You want to know about international arbitration. You want to know when it's going to work, when it isn't going to work. You want to know what will happen in the litigation context, and know what happens if the deal goes wrong. Because a lot of designing a license is about, from the lawyer's perspective, of course you assume the deal is going to go south. It's going to go south in 16 different ways, and so we're going to plan for it. That's why you bring the lawyer in. If it weren't for that, the business guys would just do a deal on a napkin, right? So
that's what we do.
Okay, so yeah, you've got to be pessimistic. You've got to be the voice of maybe this won't work. So you have to focus on the remedies. You can never know too much tax. You can never know too much about taxation and how you can exploit tertiary entities and zero tax jurisdictions to be your licensing agent, and which countries have what kind of anti-avoidance and transfer price abuse systems. Okay. If you don't know it yourself, you'd better have an international tax guy who does, because that's where a lot of the marginal profits are going to be made and lost. And just being a really good contract lawyer, yeah, you want to take the international business transactions course. You want to know how international deals work. You want to know things like standby letters of credit. All of that is grist for the mill. In addition to, it's nice if you know something about the substance of what's being licensed. I wouldn't do a pharmaceutical license no matter what you paid me, because I don't really know enough about the subject matter. And so I don't know when somebody on the other side is trying to nibble away at the rights. I'm perfectly happy in the realm of soft IP. Similarly, when you have specific expertise, great, you can then start doing the really high dollar work.
So knowing the law is great. There's a couple of courses here at Franklin UNH Law School that deal with licensing, and also just think like a business person, because yes, you're responsible for knowing the law, but you also cannot be the deal killer, as I mentioned before, because that's not the reason you're being asked to work on the deal. You're being asked to work on the deal to help it go through. So think about a business person from their side and from your side. What do those guys want? What do my guys want? What are the risks? Are those risks really as high as we think they are? And so just use your common sense. How do you develop that? Well, you're smart, obviously, because you're in law school, but then when it comes to the actual motivations of individuals and corporations, you kind of learn as you go. Interview your client, find out what their motivations are. Ask them what they think the other side's motivations are. So law, business, and these two courses that are taught here at UNH Law School.
I'd add a couple things to that. I guess from a business standpoint, rather than look at it as an adversarial kind of a transaction as you might want to as a lawyer, from a business standpoint, you want the licensee to be as successful as possible. You want it to work. You want them to use it. That's why they're going to pay you a lot of money. So that's what you're saying. Don't be the deal killer. One last comment relative to sort of career path and that sort of thing. I think if you looked at this situation 15 years ago, the amount of licensing of all kinds of IP, you would find a lot of it's flowing out of the developing world, a lot of it's flowing out of here. That is markedly different today in my experience. IP is starting to flow back. And so what has happened is there's a tremendous commerce going on, and it's growing exponentially, and I think it's going to continue to grow exponentially for as far as I'm going to be on this earth. So to me, that means licensing, intellectual property transactions of all kinds. So if I was 40 years old, I'd move to Singapore. But it's a growing field. It's a tremendously fast-growing field, and I think an interesting one too, because you just heard the combination of skills that's required in it could be fascinating. With that commercial, we will finish. Thank you.